ಅನ್ನಕ್ಕೆ ನೀರ್ ಬಿಟ್ಟಿದ್ದೀನಿ, ಬಕೆಟ್ ತುಂಬ್ತೇನೆ ನೋಡ್ರಿ. ನೀರೇ ಬರ್ತಾ ಇಲ್ಲ.
ವಾಟ್ ಆಫ್ ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ. ವಾಟ್ ಆಫ್ ಸರ್?
ಸರ್ ಈಗ ಬಂತಾ?
ಹಾ ಬಂತು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ ಓಕೆ, ಅದು ಮ್ಯೂಟ್ ಮಾಡಿರ್ತೀವಿ.
ಅದು ರೂರಲ್ದು ಮೇಡಮ್ ರೂರಲ್ದು ಅವತ್ತು ಹೋಗಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಕ್ಕೆ ಎಲ್ಲ ನೀವು ಕೆಳಗಡೆ ರೂರಲ್ದು ಅಲ್ಲಿರುತ್ತೆ. ಟೋಟಲ್ ಅಲ್ಲ ಮೇಡಮ್, ಅದು ರೂರಲ್. ಇಲ್ಲಿ ಇದು ರೂರಲ್ ಅಂದ್ರೆ ಇದಿದೆಯಲ್ಲ ಮೇಡಮ್. ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಒಂದ್ ಸೆಕೆಂಡ್ ಇರಿ.
ಹಲೋ ಸರ್, ಇವತ್ತಿಂದ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ. ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಪೇಜ್ ವೈಸ್ ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. ಫ್ರೆಶ್ ಮೆಮೊ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಸ್ಟೇ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಮೂವ್ ಮಾಡಿ ಅಷ್ಟೇ. ಸರಿ, ಗೊತ್ತಿರಲ್ಲ live streaming.
Insurance company appeal, my lord, seeking stay, my lord. Execution warrant has been issued, my lord.
How many?
My lordship, one matter is the execution warrant has been issued, my lordship. I am giving total 3 members, my lord.
Why?
Writ of execution, my lord.
That where the execution petition is. Yes.
Right there.
Fresh matter. Only so.
Stay attachment ಇದೆ, execution.
Yes.
Fresh matter stay may be granted.
Yes.
Insurance company appeal challenging the liability, writ of execution, therefore moving to me.
Which matter of which year?
24.
Yes.
Press.
My lordship, fresh matter, madam.
Yes.
My lordship, one memo for orders, my lord. My lord, insurance company deposit the amount before the trial court, my lord. However, my lord, TCR kept below in this court, my lord. Because of that, my lord, claimant not
Yes.
able to.
Notice.
Much obliged.
New fresh matter. Fresh matter. Yes.
Adjournments page wise. From admission, page 10. Serial number 32 to 36. Page 10,
30?
6.
36, yes. You have not filed wakalat since 22/11/2023. No, next. Let us see.
Page 11, 37 to 43.
41 millet, 41.
41, yes.
Kindly appellant millet, kindly refer the matter to local.
Sri Chandrasekharaya B. for appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Other side inform ಮಾಡಿ sir.
No, madam.
Page 12, 44 to 50. Page 13, 51 to 57.
Lord, serial number 54, my lord. One more appeal is there, my lord. A claimant appeal, 6620 of 2023.
You are representing whom?
In this, in present case, my lord, I am representing respondent, my lord. Claimant appeal is there, my lord, 6620 of 2023.
Council, which of the respondents you are representing?
Respondent number 1, my lord.
Spurti Hegde.
Your good name?
Shri Harsha. Shri Harsha.
Sri Harsha, representing Sri Spurti Hegde in Land Council for Respondent number 1, submits that MFA 2620 of 2023 is connected to the present appeal.
6620.
6620 is 2023 is connected to the present appeal.
Please, my.
Seeks to list both the matters on the same day. Full stop. Registry to verify and to list the present appeal along with MFA so and so on 25th September.
Serial number 56, my lord.
56, yes, Mr. Council.
56, my lord.
SV Hegde.
So kindly after 2 weeks, my lord, I will check whether the company appeal is also there, ma'am. Wakalat is not filed.
Yes, Mr. Council, for filing wakalat, it is coming since 2/2/2023. Let us see next.
Page 14, 58.
Serial number 58, my lord. I am representing the council who is on record, Raghu R. He was met with an accident and he is taking treatment, my lord. Kindly, I return after 2 weeks, my lord.
Have you informed the other side?
Yes, my lord. FS Dabale,
Sri, your good name, Mr. Council.
Prakash HC, my lord.
Sri Prakash HC representing Sri Raghu
Raghu R.
R. Land Council on record
58.6 and 7.
for respondents 2 to 4 in MFA 8175 of 2022 who are also arrayed as respondents in the connected matters submits that Sri Raghu R met with an accident
He is taking treatment.
and is taking treatment. Full stop. Seeks time. Full stop. In the light of the ground urged, list all the matters on 25th September.
Please, Machugan.
Page 15, 59 to 61.
Lordship 59. Connected matters posted on 22/10, my lordship. Yesterday was listed the matters. Today, only one matter was listed. The connected yesterday, it is posted to 22nd October, my lordship. Connected.
What are the numbers of the connected?
I've already given, my lordship.
Number ಹೇಳಿ sir.
185 of 23, 74, 86,
One number ಹೇಳಿ sir.
Ah.
Main number.
185 of 23.
185 of 23 connected cases.
Sri Janardhan Reddy, Land Council for the appellant submits that MFA so-and-so is connected to the present appeal and that the said appeal was ordered to be listed on
22/10, my lordship.
22/10, full stop. Seeks to list the present matter also on the same day. Full stop. In the light of the submission thus made, list the present matter along with MFA so-and-so on 22/10.
Much.
Serial number 61, my lord.
Yes.
The matter is referred to Lokadal. I already informed the company appeal, referred to Lokadal.
You are Mr. Vishwanath.
I
Pujari.
am Ishan Pujari.
Sri Vishwanath Pujari K, Land Council for the appellants seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Page 16, 62 to 67. Page 17, 68 to 71.
68.
My lord, one submission, my lord. 66, my lord.
Yes,
My lord, kindly call this matter next week, my lord. They are sending the wakalat today. They are dispatching it.
Vijay Kumar appears online and seeks time to file wakalat. Full stop. Hence, stand over to
My lord,
24th October.
serial number 68, my lord, 68. My
Yes,
lord,
sir.
records are awaited.
Yes, I am for the appellant
Records not received.
not received.
So kindly after 2 weeks, my lord.
Await records from the consent tribunal. List on 19th September.
71, madam.
71, yes.
Waiting the TCR.
Huh?
TCR is necessary.
Awaiting 98.
71 appellants, madam.
Await records from the consent tribunal. List on 24th October.
Can permit, serial number 22, I may permit to withdraw the appeal. ma'am. Serial number 22.
22,
Yes, ma'am.
Keshavamurthy,
Yes, my lord.
was KN.
Appeal may be dismissed as not procedural.
Why you are intending to withdraw the appeal?
Actually, there was double petition has been taken.
Land Council for the appellant, Sri Keshavamurthy B,
Yes,
files a memo seeking permission to withdraw the appeal. Full stop. Permission as prayed for is accorded. Full stop. The appeal is dismissed as not pressed.
Much of it.
ನಾಳೆ serial number 1 for orders SV Hegde Mulkun, Joshua Samuel.
Appear for respondent number 1 in this case.
Yes.
My lords, I had moved a memo requesting that the matter be posted today. Here, lords, there is a stay order which is granted on 15/7/2022. There is a direction for the appellant to deposit 6,63,270 along with interest before the tribunal. The respondent number 1's father is suffering from 4th stage of cancer. So I have moved an application for withdrawal of the amount before the MACT. My lords may kindly may be permitted to file these documents which substantiate the father is suffering from.
Is it a first matter, my lord?
First matter.
My lord, I appear for the appellant.
Yes.
My lords, kindly turn to page number 4, page number 3. It is completely metastasized. And kindly see the next two hospitalization in this month itself, 14/8/24 and 25/8/24, respiratory failure. It has metastasized, it has gone into the lungs, and it is metastasized all over the body.
My lord, may I make one submission, my lord?
So any objection for permitting?
My lord, some amount may kindly be released, my lord, because injury and injury case, and the question is regarding negligence and quantum.
I would like to make it clear that it is the reports that I have produced are the respondent number 1's father. It is not the respondent number 1, it is her father. And there is another appeal which is also pending, which is before the division bench. I have moved a similar application there also.
Well, but this application is concerned, my lord, that is in respect of his father. My lord,
Yes.
it is pending before the division bench. I think
Yes. That is
we
before
are
the division.
confining only to this case.
No, I'm just informing the court that I have.
50% of the deposited.
50%
There may be a
of
direction to the tribunal to release that amount.
My lord, 50% of the 50%.
Before the tribunal, huh?
Yes, my lords, as per order dated 15/7/2022, my lords.
My lord, court is not visible, my lord. 50% of 50% may kindly be released, my lord. 50% of the deposited amount.
IA 1 of 2024 is filed. By respondent number 1 to the appeal, who is the claimant, seeking the court to permit her to withdraw the deposited amount. Heard. Sri, you are Mr. Samuel.
I am appearing for Samuel. I am MC Timaya for J. Hudson Samuel.
Heard. Sri.
MC Timaya.
MCK.
MC Timaya.
MC Timaya. Heard. Sri MC Timaya, who argued representing Sri J.H. Samuel. Full stop. Also heard Sri S.V. Hegde Mulkun, Land Council, who appears online and represents the insurance company. Full stop. Next. Sri J.C. Timaya submits that the claimant's father is suffering from cancer and the claimant is spending huge amount for his treatment. Full stop. She requires the deposited amount for continuation of treatment of her father, and therefore permission may be accorded to the claimant to withdraw the deposited amount. Full stop. Next para. Sri S.V. Hegde Mulkund, Land Council for Insurance Company, states that some amount out of the deposited amount may be permitted to be withdrawn by the claimant. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the ground projected, that is ill health of the father, and that the amount is required for treatment, this court considers desirable to permit the petitioner oblique claimant to withdraw 50% of the deposited amount. Full stop. Thus, the petition is allowed. Full stop. The petitioner oblique claimant is permitted to withdraw 50% of the deposited amount forthwith. Full stop. Tribunal to disperse the amount on due identification.
Obliged.
Mr. Counsel, you have not furnished the requisites for issuance of notice to respondent number 3.
I will furnish, my lord.
Land next para. Land Council, Sri S.V. Hegde Mulkund seeks time to furnish the requisites. Full stop. A week time is granted to furnish the requisites. Full stop. On
Well,
furnishing the requisites, office to send notice to respondent number 3.
My lord, the remaining amount may kindly be deposited in FD, my lord.
Already there is an order.
There is no order for FD money.
That order you write. After the disbursement, the balance shall be kept in fixed deposit. Yeah, balance shall be kept in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Yes.
May I seek the indulgence of the court in requesting that the matter be posted after 4 weeks after service of, or immediately after service of notice, my lords. If you can.
Notice to the respondent number 3 in the appeal as well as in IA 1 of 2022. List on.
My lord, connected matter, my lord, pending before the. My lord, connected matter is pending before the division bench.
You take steps.
I will take steps, my lord.
30-10. Yes.
Oblige me.
Serial number 2, Suma K.
Second response.
I'm the advocate for the appellant. Notice to R1 may please be awaited and TCR may be called.
I have not received the appeal memo copies. Appeal memo copies are not received. It is directed case.
I will serve a copy today.
Suma K for appellant appears online. Full stop. Sri L. Srikanta Rao, Land Council for respondent number 2, appears physically before this court and submits that appeal papers were not served upon him. Full stop. Appellant is directed to serve copies of appeal papers at the chambers of Sri L. Srikanta Rao. Full stop. Await service of notice upon respondent number 1. Full stop. In the meanwhile, call for the records from the consent tribunal. Records. Await notice in respect of response. List on 30-10.
Much obliged.
Serial number 3, AM Venkatesh. Sripad V. Shastri.
Sripad V. Shastri said, my lord, his mother's ceremony is in Kumta. He has telephoned to me in the morning. You want some time. As far as first objection is concerned, my lord, That New India Assurance Company, they are taped as New India Insurance Company. That office objection may be over.
New India Assurance Company is different and New India
No,
Insurance.
my lord, only company. New India Assurance Company, New India Insurance Company is not there.
You file a memo to the effect that both are one and the same.
Both are same, I filed memo. Correct, sir.
Await records from the consent tribunal.
Records.
List on
Well, also we take it as memo filed.
28th October. Yes, sir.
28th October, by that time I filed the memo.
Serial number 4, Ashok Kumar M, Guru Prasad BR.
Alerts, in this case, I have deposited 50%. That memo I will proceed.
What?
And as far as R2 is concerned, it is United Insurance, my lord. Any advocate panel may be there. R1 they have filed wakalat already.
Sir.
Sri L. Srikanta Rao is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri L. Srikanta Rao. Learned counsel for the appellant, Sri Ashok Kumar M, submits that 50% of the award amount has been deposited and that he would file the acknowledgement to that effect in the office on this day. Full stop. List on 24th September.
Much obliged.
Serial number 5, BC Shivannegowda, Sharat Kumar.
Weeks time I will take steps against R10 and 11. Since I am challenging the liability.
You have to furnish the requisites, Mr. Counsel.
Please, man, I will produce. Weeks time I will grant, man, I will.
Sri BC Shivannegowda seeks a week time to furnish the requisites. Full stop. Time as prayed for is granted. Full stop. On furnishing the requisites, office to send notice to respondents 10 and 11.
Please.
No representation for other respondents on call. List on
After
13th November.
Much.
Serial number 6, Raju S.
Number the appellant ballot. Filing a memo for dispensation of R1. R2 is the Bajaj Alliance. I may be permitted to take notice to standing counsel.
Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Heard Sri Raju S. Learned counsel for the appellant. Why it should be dispensed with?
R1, madam.
Why it should be dispensed
He
with?
satisfied the award before the trial court, madam, accepting the liability.
Learned counsel Sri Raju S. submits that as respondent number 2 accepted the liability, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however at the risk of the appellant.
R2 Bajaj Alliance. I may be permitted to take notice to standing counsel.
Sri H.S. Lingaraju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri H.S. Lingaraju.
Sridhar Mala,
H.S. Lingaraju.
Lingaraju, sir.
List on eight 11.
Serial number 7, Sumana S.N.
My lord, 1 week time may be granted
For what,
to
Amma?
furnish to furnish notice and to issue notice, my lord.
Your good name, Amma?
Sumana, my lord.
Sumana S.
Heard. Miss Sumana S.N. Land counsel for the appellants who appears online. Sri Ravi S. Samprati is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri Ravi S. Samprati. Full stop. Ms. Sumana S.N. seeks time to furnish the requisites. Full stop. Time for 2 days is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 2. List on 8/11.
Please, my lord.
Serial number 8, Sripad Shastri. Serial number 8.
No representation on appellant side on call. Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. As per the contents of the said memo, respondent number 1 remained ex parte before the tribunal, and thus notice to respondent number 1 is required to be dispensed with. Full stop. Having considered the contents of the said memo, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Sri A.N. Krishnaswamy is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri A.N. Krishnaswamy. List on 7/11.
Serial number 9, K.V. Nayak. Respondents served under are 1 and 2.
I represent counsel for appellant. To 1 week time, may be granted.
Your good name, Mr. Counsel.
Nagaraj Hegde. Nagaraj Hegde.
Sri Nagarajaya K, representing Sri K.V. Nayak, seeks a week time to furnish the requisites. Full stop. Time as prayed for is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 3. List on 11/11.
Nagaraj Hegde. Serial number 10, Nagaraj Hegde. In this case, I pay for appellant. Respondent number 2, insurance company. Panel counsel may be directed to take notice for Oriental
Heard.
Insurance.
Sri Nagaraj Hegde, Learned Counsel for the appellants.
United India Insurance Company.
United India.
United India.
You have mentioned as New India Assurance Company?
Sorry, madam. United India Insurance. Sorry.
Huh?
United India Insurance.
No, Mr. Counsel, it is New India Assurance. You have given another.
Sorry, sir.
Srimati Geeta Raj is called upon to accept notice for respondent number 2 and file wakalat subject to the entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. List on 28th October.
Serial number 11, E. Vijay Kumar.
My lord, I am for the appellate, my lord.
Yes.
This matter is connected with MFA 7352/23 filed by the claimant, my lord, where Mr. Abdul Sabur is appearing for the claimants.
Have you deposited the our?
Yes, my lord, a sum of rupees, my lord, 2,80,348 has been deposited on 23/8/2000. Please, my lord.
You have not filed the acknowledgement.
My lord, I'm going to file it, my lord.
Land Counsel Sri D. Vijay Kumar appears online and submits that the amount as ordered was deposited and he would be filing the acknowledgement during the course of the day. Full stop. Land Counsel also states that MFA 7352 of 2023 is connected to the present appeal. Full stop. In the light of the submission thus made, list the present appeal along with MFA so and so on 23rd September.
Please, my lord.
Sir, 7352 of 23 alva.
Howದು 7352 of 23, correct.
Serial number 12, Samarth Prakash.
Silent, my lord. With respect to the deposit, my lord, the check is in transit. They've dispatched the check. It's not yet reached me, my lord, to enable me file it. I just seek for 1 week's time. I'll deposit it.
Land Counsel for the appellant, Sri Samarth Prakash, seeks a week time to deposit the amount as ordered by this court through orders in IA 2 of 2024. Full stop. Time as prayed for is granted. Full stop. Await service of notice upon respondent. List on 30th September 30.
Much obliged.
Serial number 13, C. Shankar Reddy.
In this case, the certified copy of the judgment, 2 pages are missing, my lord. I applied for certified corporation. 2 weeks time.
Land Counsel Sri Shankar Reddy C. seeks time for 2 weeks to comply the office objections. Full stop. Time as prayed for is granted. Stand over to 14th October.
Serial number 14, B. Pradeep.
Hearing for the appellant. I have deposited the amount, my lord. For the MSC, I have filed acknowledgement also.
You have not filed, you filed only memo.
Please, my lord, before MSCT, we have deposited, my lord, 7 lakh.
You have to file the acknowledgement.
Please.
Land Council Sri Pradeep B seeks time to file the acknowledgement of having deposited 50% of the award amount as ordered by this court. Full stop. Time for a week is granted. Full stop. Await service of notice in respect of respondents 1 and 2. List on 26th September.
Serial number 15.
My lord, I appear for R2. I have filed wakalat yesterday, my lord.
I have furnished the PF fees today morning.
R2, I have filed wakalat, my lord, yesterday. Somsekhar.
Sri S. Somsekhar
Yes,
appears,
no initials, my lord, just Somsekhar.
Sri Somsekhar appears online and submits that he filed wakalat
Yesterday, ma'am.
for R2 on
27, 27/8.
27/8/2024. Full stop. Registry to verify and to place the same on file.
PF paid fees today morning.
What about R1?
I paid today. I have taken steps today morning, please.
Land Council Sri Ravish Benny submits that needful has been done. Full stop. Office to verify and to send notice to respondent number 1. List on 25th October.
Serial number 16, HC Rishabhendraya.
Yes, my lord. I have taken steps to R1, my lord, today morning.
Land Council Sri H.C. Rishabhendraya submits that needful has been done. Full stop. Office to verify and to send notice to respondent number 1.
And you have deposited
Full stop.
6,80,000.
Await service of notice upon respondent number 3. Full stop. You have deposited.
Yes, madam.
Land Council also states that he deposited 50% of the award amount as ordered. Full stop. Office to verify. List on 12th November.
Serial number 17, B Pradeep.
Counterpart advocate has filed an application 152 minutes. Still it is pending. 2 weeks time may be granted.
Land Council Sri Pradeep B for appellant seeks time for 2 weeks to furnish the corrected copy of the impugned order. List on 23rd October.
Serial number 18, Ravish pending.
Needful done, please. Await notice of R1 and there 2 and 3 I have taken steps today, please.
For 2 and 3,
I have taken steps today. Needful done, please.
Land Council Sri Ravish Penny submits that needful has been done. Full stop. Office to verify and to send notice to respondents 2 and 3. Full stop. Await service of notice upon respondent number 1.
25 test, 10, please.
List on
25 10 connected the Malina
25th,
25 10.
25th.
10.
List on 25/10.
Serial number 19, HC Rishabhendraya.
More for dispensation notice to R2, my lord. Only quantum and negligence we are challenging. And with respect of check is ready, my lord.
Heard Sri H.C. Rishabhendraya, Land Council for the appellant. Full stop. Land Council files a memo seeking dispensation of notice upon respondent number 2. Full stop. Land Council submits that respondent number 2 is a formal party and therefore notice to respondent number 2 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 2 stands dispensed with, however, at the risk of the appellant. Have you deposited the
My
amount?
lord, check is ready, my lord. You have to deposit before the Ramnagara. 1 week time may be granted. my lord.
Next, learned counsel seeks a week time to file acknowledgement of having deposited 50% of the award amount before the tribunal. Full stop. Time as prayed for is granted. No representation on respondent's side. List on 5th November.
Serial number 20. SV Hegde, Volkan. Serial number 20. SV Hegde.
No representation.
My lord, I am appearing for the appellant, my lord. Notice is awaited, my lord.
Yes, what about deposited? What about deposit of amount?
My lord, the amount is deposited as per my information. I will file the necessary acknowledgement, my lord.
You have filed the acknowledgement, huh?
I have not filed, I will file it, my lord, and the 2 weeks may kindly be granted.
Sri S.P. Hegde Mulkund appears online and seeks time to file acknowledgement of having deposited the amount as ordered by this court. Full stop. Time for a week is granted. Full stop. Await service of notice upon respondents 1 to 4. List on 22nd October.
Serial number 21. D. Vijay Kumar.
My lord, I am for the appellant, my lord. A week's time may be granted to pay the PF to respondent number 1 to 3. My lord, I have informed the BMTC, my lord, they are going to send the information whether they are deposited or not. My lord, a week's time may be granted, my lord, so that if they are deposited, I will file the acknowledgement before the
D.
court.
Vijay Kumar seeks a week time to do the needful. Full stop. Time for a week is granted for furnishing the requisites as well as for filing the acknowledgement of having deposited the amount as ordered. Full stop. On furnishing the requisites, office to send notice to respondents 1 to 3. List on
It is for the second time, yes.
14th November.
Much obliged.
Serial number 22, withdrawn. Serial number 23, Prakash MH.
Withdrawn, huh? Okay. Sorry.
Yes.
For the appellant, your lordship.
Sir, 22 withdraw ಆಗಿದೆ sir. Srinivas KN.
Yes, yes, much obliged. Thank you.
Yes, yes.
23.
Yes, Amma.
Your lordship, we had filed for recall application. Last time there was a mistake on my part to file in the application. It was filed as an appeal, so I have corrected and filed it in a proper way, your lordship.
It was dismissed on 1/2/2023.
Please, your lordship.
You filed an application to recall with delay of 417 days.
Please, your lordship.
I will take notice for IFCO.
IA 3 of 2024 is filed, seeking the court to condone the delay of 417 days in filing the appeal.
Please, your lordship.
In filing
Recall
the
application.
Recall application. your
Recall application.
What did you mention in your affidavit, in your petition, Amma?
Lordship, that is for the filing of The appeal, we filed a recall application. I've corrected the recall application and I filed on 27/7/2024. It was stated that I had filed stating delay in filing the appeal. So I have corrected and filed saying that 417 days in filing the application.
When did you file? When did you file the corrected or?
29/7/2024.
29/7 only. Who's good to come? Yes, ma'am. Yes, what is your submission?
Your Lordship, I'll not press the application IA number 1 and 3. So this may be allowed. I will file a because I had, again, it is inadvertently filed with the wrong thing. I'll correct it, Your Lordship.
IA 3 of 2024 is filed, seeking the court to condone the delay of 417 days in filing the appeal. Full stop. Miss Nitya, representing Sri Prakash MH, Land Council on record for the petitioner appellant, submits that the application for condoning the delay is in respect of the present application is for condoning the delay in moving an application to recall the order dated 1/2/2023, but not in preferring the appeal. And by oversight, a wrong prayer was mentioned. Full stop. Submits that she would not press the present application, that is IA 3 of 2024, and move a fresh application. Full stop. Or permission may be accorded to correct the prayer column. Full stop. Next, permission to correct the prayer is accorded. Full stop. However, the record discloses that the appeal was dismissed due to non-compliance of office objections on 1/2/2023. Full stop. The appellant kept quiet for more than a year and thereafter moved an application to recall the order dated 1/2/2023 and the present application to condone the delay of 417 days in moving the said application. Full stop. Having perceived gross negligence on part of the appellant in pursuing the matter, and as it is also found that the appellant has wasted the time of this court, the permission to correct the prayer portion is accorded on cost of ₹10,000 payable to High Court Advocates Library Fund.
My lord, court is not audible and also video is. Audio and video is not.
ಅದೇ ಹೊಟ್ಟೋಗಿದೆ ಸರ್, ನೆಟ್ವರ್ಕ್ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ ಅವ್ರದ್ದು.
ಹೌದು.
ಹಿಂಗೆ ಆಗ್ಬಿಡುತ್ತೆ, ನಮ್ ಕೇಸ್ ಬಂದಾಗ ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ, ಏನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಹಂಗೇನ್ ಮಾಡಲ್ಲ, ಗೊತ್ತಾಗುತ್ತೆ ಅವ್ರು ನೋಡ್ತಾ ಇರ್ತಾರೆ.
ಡಿಸ್ಮಿಸಲ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಹಿಂಗೆ.
ಇರ್ಲಿ ಕೋರ್ಟ್ ಕೇಳಿಸುತ್ತೆ, ಮಾತಾಡ್ಬೇಡಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, court officer.
The other connected cases, notice was served to the owner, my lordship. This case was issued for the notice to the second respondent. In connected cases, he was received, my lordship, already in record. Siddhalingappa is the owner of the vehicle. In our matter likely to be settled, my lordship, refer to the matters for local.
MFA 1577 of 2023, there is no respondent appearance of respondent in this.
Subsequent, the vehicle was sold to the vehicle, same cause of action, my lordship. So 4 matters may be likely to be settled local adalat, my lordship, refer the matters.
Sri Janardhan Reddy, Land Counsel for the appellant in all the appeals, that is MFA so and so, 4 appeals, seeks to refer all the matters to Lok Adalat. Full stop. Hence, the matters are referred to Lok Adalat for settlement.
Serial number 26, B. Pradeep, Prabhakar KL.
For the appellant. That's for weeks time, my lord, furnished.
Land Counsel Sri Pradeep B seeks a week time to file acknowledgement of having deposited 50% of the awarded amount. Full stop. Time for a week is granted. No representation on respondent side on call. Admit. List the matter under the caption final hearing on 21st October.
Serial number 27, Sri Harsha.
For appellant, my lord, claimant appeal for enhancement, my lord.
Heard Sri Harsha AK, Land Counsel for the appellant. Sri PB Raju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Full stop. Appellant to serve copies of appeal papers at the chambers of Sri PB Raju.
Please.
Full stop. Wakalat to be filed within 2 weeks.
Please.
Full stop. Issue notice to respondents 1 and 3 on furnishing the requisites in the appeal as well as in IA 1 of 2024. List on 19th November.
Please.
Serial number 28, BC Shivanya.
This case I appeal for the flood insurance company challenging the judgment and award passed by the tribunal on the ground that may not implication of the insured vehicle. As per the MNC fall from motorcycle. Subsequently, insured car has been implanted in the Elise accident. The delay of 10 days, lodging the complaint also, therefore challenging the liability.
Heard, Sri B.C. Shivanagowda, Land Counsel for the appellant. Next, IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MBC 2211 of 2021 dated 27/2/2020. Next, Land Counsel Sri B.C. Shivanagowda submits that the alleged offending vehicle was implanted and a wrong claim was laid. Land Counsel also states that there was delay of 10 days in giving complaint to police. Land Counsel submits that the tribunal has fastened liability upon the petitioner appellant wrongly, and thus an appeal is filed. Land Counsel seeks to stay the operation of the impugned award thus. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Next, therefore, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 2211 of 2021, dated 27/2/2024, shall stand state until further orders on the appellant, on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to respondents in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisites. List on 11/11.
Much.
Serial number 29, Rupesha B.
Here for appellant Millard.
Yes, Mr. Counsel.
Appear for appellant Millard. Owner's appeal Millard. Millard, accident has occurred on 12/10/2015 Millard. On the day itself, Millard, the appellants herein have lodged the complaint.
Who are these appellants? 2 appellants are there?
Millard, the owner and the driver, Millard, the alleged driver. The Millard respondent, who is the petitioner before the court, Millard, he himself came and dashed against this car, Millard, and fell down, Millard. In this regard, on the same day, we have lodged the complaint. On the other hand, Millard, they have lodged the complaint on 17/10/2015, stating that the accident has occurred, Millard. They themselves, Millard, my complaint was not considered. It was marked as, Millard, my postal acknowledgement and complaint was marked as marked in the respondent evidence. That was not considered by the tribunal, Millard. There is a contributing negligence, Millard. Millard, a car which is parking left side of the road, Millard, they came and dashed against the car.
Heard. Sri Rupesha B. Land Counsel for the appellants. Full stop. Next, IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Chamraj Nagar, in MVC 94 of 2016, dated 16/3/2024. Next, Land Counsel Sri Rupesha B submits that the first petitioner is the owner and the second petitioner is the driver of the car,
Car, my lord.
of the car which is involved in the accident. Full stop. Land Counsel submits that the accident occurred due to the negligence of the respondent claimant, but not due to the negligence of the second petitioner herein. Full stop. Land Counsel also states that the second petitioner gave complaint to police also. Full stop. But without appreciating these facts, the tribunal fastened liability upon the petitioner's appellants, and therefore an appeal is preferred. Full stop. Land Counsel thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditional. Next, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Chamraj Nagar, Motor Accidents Claims Tribunal, Kollegalam. Earlier also you write Kollegal. Kollegal shall stand stayed until further orders on the petitioners depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, registrate is directed to invest his same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to the respondent in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisites. List on 12/11/2024. Taking judgment, will take it at 2:30.
Serial number 30 at 2:30, pass over.
Much obliged.
Serial number 31.
And for the appellant in 54/54 of 2021. my lord.
Respondent
Nirmala.
claimant, my lord.
This is the case, my lord, where shall I make my submission, my lord?
Yes.
My lord, this is a case, my lord, the claimant has stated the bus number as 3 KA 19F3311 in the complaint and in charge sheet, my lord. Then subsequently, my lord, in the other document, my lord, the bus number has been shown as 19F3082, my lord. There is no proper explanation, my lord, that how the earlier bus has been changed. Even, my lord, he has stated in the wound certificate also, my lord, that he has met with the accident of the so-and-so bus 30301111. And in complaint also, my lord, he has mentioned the same bus number. And in wound certificate also, my lord, before the doctor, he has stated that the bus what he was traveling was 311. And only subsequently, my lord, at the time of filing of the charge sheet, my lord, the police have taken 3082 bus. My lord, even my lord, MLC report has been filed after a period of 6 months, my lord. Motor vehicle accident, this thing report has been filed after a
Then
period
we'll
of 6
admit,
months, my
Amma,
lord.
we'll admit and we'll call for the record.
Records are there, my lord, already.
That's already secured.
Records received. Yes, yes. Please proceed, Amma.
Yes, ma'am. My lord, there is no sufficient reason that, my lord, how this other bus has come into picture, my lord. Even the ME accident report, my lord, has been taken after a period of 6 months, my lord. 28/6/2018, which is marked as exhibit P5, my lord. The lordship may kindly see, my lord. And even wound certificate also, my lord, he has stated KA 19F331. Only subsequently, my lord, while filing the charge sheet, my lord, they have stated 3082. That too, my lord, that charge sheet has been filed on 10/9/2018, after a period of 9 months, my lord. The accident happened in January, my lord. And my lord, this is all completely concocted and colluded with the police, my lord. He has claimed the award, my lord. The police also have colluded, you know, there is an inordinate delay of even filing the charge sheet, my lord. And the police have not given any proper explanation how they came to know the other bus of 3082. That too in September, my lord. When the accident has happened in January, the charge sheet is filed in 10/9/2018. And even, my lord, in this is inspection of the vehicle is also done in somewhere to after a period of 6 months, my lord. This all shows that, and he has not produced any ticket having traveled in that bus, my lord. And even there is a delay of 11 days to file the complaint also, and that there is a discrepancy in the hospital admitting and discharge also, my lord. He says in one document, he says that I was admitted to on 26/1/18 as per the summary. And in P6, my lord, which is the document of wound certificate, he says that he has been discharged on 2/2/18. Hence, my lord, even, my lord, the disability has been taken as on a wrong side, my lord, and the income. So I say that, my lord, the is a completely concocted and then false claim by the claimant, my lord, against the bus. After a period of 11 days, my lord, he had suffered a severe injury, my lord. When he has suffered vertebral body of L3 with repatriation of fragments and compression of nerve root, he cannot stay 11 days in the house or whatever it is, my lord. He says after 11 days, he comes to and then file one complaint of saying some other different bus.
Hmm. 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 Hmm.
ಜ್ವಾಲಕುಮಾರ್ ಜ್ವಾಲಕುಮಾರ್
ನಿಮಿಷ ಇದೆ ನನ್ನ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಕೇಸ್ ಬರ್ತಾ ಇದೆ.
ಜ್ವಾಲಕುಮಾರ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊ ಮ್ಯೂಟ್ ಮಾಡು. ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಆಡಿಯಬಲ್.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ವಾ?
ಇಲ್ಲ.
ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂ ಇದೆ. ಒಂದು ನಿಮಿಷ.
ಓಕೆ.
Amma, what is the evidence of RW1?
My lordship, the RW1 is the driver of the KSRTC bus. My lordship, he has admitted the accident, and he admitted that he was driver on the date of accident. My lordship,
Court officer? Court officer? ಇಲ್ಲಿ ಏನು ಕೋರ್ಟ್ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಕಾಣ್ತಾನೆ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್? Network ಇಲ್ಲ. ಅಲ್ಲಿ ಏನ್ ನಡೀತಾರೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
1,500.
Loss of earnings during data period, how can it be 72,000?
For 6 months, my lordship.
My lord, I'm not able to see the court proceedings, my lord. My lord, even it is not the case, my lord, that the 3082 accident, they have taken it and say that the driver has admitted. On all the documents, my lord, he claims that 3311, 3311 is the bus where he traveled in the bus, and in wound certificate, in complaint, everywhere he has written that bus. Only after a period of 6 months, my lord, the police have charge sheeted that bus. And there is absolutely no explanation, no documents to show that how that bus came into picture, my lord. Even, my lord, he says that
What about the evidence of RW1, Amma?
My lord, that is, he has given the evidence for this bus, my lord, 3082. Not for the 3311, which he has claimed it that he was.
He stated that during relevant time, that bus was proceeding at that
Oh,
place.
no, my lord, no, not that bus, my lord. It was the bus KA 193311, not 3082. This bus came into picture only a period of 6 months. After a period of 6 months, the police
So
have charged
whether
sheeted.
that bus was playing at the relevant time at the place of
No,
accident?
my lord, that is what this bus was. I don't know whether this bus was playing or not, but they have taken this suddenly this bus 3082, seeing that which is running on that road.
Whether you have produced any evidence to show that bus was not at all playing on that road at that relevant time at that place.
Kindly permit me sometime, my lord, I'll get the
My
records.
lordship, like several times, kindly see the order sheet.
No, even I have, it is not me taken, my lord, it is proceedings of the lordships have adjourned it for many other reasons.
Not
My
only
lord,
before this
kindly-
lordship, my lordship.
Because this question was not,
took
my lord,
several time, my lordship, saying one or several reasons.
this question was not raised, my lord, whether I have produced any document to show that whether
My
that.
lordship, I have already produced the
that is
statement
what
of
I'm telling you,
driver,
my
my
lord.
lordship.
That is what I'm telling, that they have brought a new bus, 3082, after a period of 6 months.
That is the duty of the investigation officer, my lordship, within reasonable time. He has to.
If he has colluded, and how come he filed in complaint, wound certificate, and FIR
My
everywhere?
lordship, the offending vehicle is the KSRTC corporation, government vehicle.
Not that, my lord.
Implicate the vehicle, my lordship.
So many buses will be running, my lord, just because just catch hold one bus which is running on that road and then file, ask the police to file the charge sheet against that bus, my lord.
Lordship, kindly
How can-
see the I have given document, my lordship, page number 3, my lordship.
I'm not denying that
Specifically-
document, my lord. 3082 bus is the one which they have filed the charge sheet against the driver. How can he claimed in all the documents, my lord, FIR, complaint, charge sheet, and then his wound certificate also, my lord, he states that 311. How specifically he brought that bus, my lord?
But the driver of offending vehicle has pleaded guilty, my lordship.
No, not that is what I'm telling you, my lord. They when they brought that after a period of 6 months, they filed the charge sheet. Then that driver came into picture. Why he has written that 3311 instead of
You are appearing online and you are arguing the matter on merits. How can we hear you or that counsel, and how can we go through the record? When you want to submit your contentions for final hearing, please take time to come to the open court and submit.
Yes, my lord. I'll come.
Yes.
My lordship, kindly pass over the matter. I will furnish the document, my lordship.
No, let him file it, my lord.
Document,
Give
my
the
lordship.
copy to me. Let him file it before
My
the.
lordship, I have produced the statement of
Now we
driver and
those documents we cannot consider. How can you furnish certain documents and ask the court to look into the contents of the documents, whether as they are not part and parcel of the record, only the evidence will be taken into consideration.
But in evidence, the driver has admitted the accident, my lordship. And that day, my lordship, he was the driver of the offending vehicle.
Heard. Heard. Srimati. Yes, Nirmala. Learned counsel for the appellant in MFA 5454 of 2021, who appears for the respondent in the connected matter, that is MFA 2763 of 2022. Full stop. Learned counsel appeared online and argued. Full stop. Next. Also heard Sri Vijay Kumar T. Learned counsel for respondent in MFA 5454 of 2021, who is the appellant in the connected matter, that is MFA 2763 of 2022. Full stop. Next, for the sake of convenience of discussion, the appellant in MFA 5454 of 2021 would be referred as the corporation and the respondent as the claimant. Hereinafter. Next. These two appeals arose from the order that is rendered by the Motor Accidents Claims Tribunal, Mysore, in MVC 978 of 2019, dated 26/2/2021. Full stop. While the corporation filed an appeal disputing its liability, the claimant filed an appeal seeking enhancement of compensation. Full stop. Next, the crux of the case, as projected by the claimant before the tribunal, is that on 23/1/2018, he was proceeding in a KSRTC bus bearing registration number KA19F3082.
No, my lord. 3311. As per his claim.
To his native place, that is KR Nagara. Full stop. At about 10 p.m., when the bus reached near Yelwal, the driver of the bus, without noticing the humps on the road, drove the bus, due to which the claimant, who was sitting on the last seat of the bus, sustained injury to his backbone and fell in the bus itself. Full stop. Next. The claimant reached his home with the help of co-passengers. Full stop. Since he could not tolerate pain, he was admitted at Kamakshi Hospital, Mysore on 26/1/2018 for treatment. Full stop. The doctors identified that he sustained commutated compression fracture of lower 1/3 the doctor identified that he sustained a grievous injury. Full stop. Next. Arguing the matter, Srimati S. Nirmala for the corporation submits that the accident occurred on 23/1/2018 as per the version of the claimant, but a complaint was given on 3/2/2018. Full stop. No reason is accorded as to why there is delay of 11 days in giving complaint to police. Full stop. Though in the complaint and as well as before police, the claimant contended that he sustained injury while traveling in the bus bearing registration number KA19F 3311, charge sheet was laid by police that the bus involved in the accident is KA19F 3082. Full stop. No reason whatsoever was given by the police as to how they found that the bus bearing registration number KA19F 3082 is involved in the accident. Full stop. Though the fact that the involvement of the bus the fact of discrepancy of the registration number of the bus and the involvement of the bus itself in the accident is projected, yet the tribunal fastened liability against the corporation, and therefore the corporation filed an appeal. Full stop. Land Council thereby seeks to dismiss the claim application that is filed by the claimant. Full stop. Next, vehemently opposing the submission thus made, Land Council for the claimant Sri Vijay Kumar T submits that the claimant could not notice the registration number of the vehicle, and by the information given to him by others, he gave complaint to police that the bus involved in the accident is KA19 3311. Full stop. Land Council also states that the said number is mentioned in the wound certificate as well. Full stop. However, the registration number of the bus that is involved in the accident is KA19F 3082. Full stop. Land Council contends that after investigation, police found the correct bus. Police found the registration number of the bus and late charge sheet against the driver of the bus. Full stop. Land Council also states that the driver of the bus who was driving the vehicle at the time of accident was examined by the corporation as RW1. Full stop. RW1 did not deny the involvement of the bus bearing registration number KA19F3082 and that the appellant and that the claimant was traveling in the bus at the time of the incident. Full stop. Land Council also states that the driver of the bus admitted his liability before the criminal court and he was imposed fine. Full stop. Land Council thereby imposed fine. Full stop.
My lord, the charge sheet and then IME has been done after a period of 6 months and 9 months. That may kindly be brought in this thing, my lord. Because charge sheet is filed in September and then.
In reply to the said submission, Land Council Srimati S. Nirmala contends that even the police subjected the bus for verification and examination after 6 months of the date of accident, which itself so shows that the bus was falsely implicated.
Flagship. But that has not been challenged by the.
When we are
Respond.
dictating the order, we cannot appreciate involvement. If you go on adding,
Before
the flow will go.
learner friends.
No. Yes. What did you write? Next para. Undoubtedly, the claimant took a plea in the complaint that the bus which is involved is bearing registration number KA19F3311. Full stop. The same is reflected in exhibit P6 wound certificate also. Full stop. However, charge sheet is laid stating that the bus which is involved in the accident is KA19 F 3082. Full stop. RW1 RN Jagadish gave evidence to the effect that the accident did not occur due to his negligence. Full stop.
Page number 17.
His statement is that his evidence is that he was driving the bus bearing registration number KA 19F3082 on 23/10/2018. He also stated that no accident occurred while he was driving the bus and that he was not driving the bus in a rash and negligent manner. Full stop. The version of next. Though it is found that the claimant initially took a plea that the vehicle involved in the accident is KA 19F 3311, the police of his contention is that the bus that is involved in the accident is KA 19F 3082. Full stop. Police, after investigation, laid charge sheet duly mentioning that the bus which is involved in the accident is KA 19F 308. Full stop. Admittedly, the corporation will maintain all the data, including route chart of all the buses under its control. Full stop. Therefore, it is not a difficult task for the corporation to establish in certain terms the bus which plied on the relevant route at the relevant time. Full stop. But for the reasons best known, the corporation has not taken the said task. Full stop. Furthermore, as earlier mentioned, RW1 did not deny the fact that the bus bearing registration number KA 19F 3082 was plying at the place of accident on the date of accident at the time given by the claimant. Full stop. Therefore, this court is of the view that the tribunal did not err in appreciating the evidence put forth by the claimant and allowing his claim for compensation. Full stop. Next. In the appeal filed by the claimant sought for enhancement of compensation. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 3,61,505 as compensation, divided under different heads as under A to U. It is not in dispute that the appellant sustained fracture of L3 vertebra. Full stop. Also, it is not in dispute that the appellant underwent surgery. Full stop. However, the claimant underwent surgery. Full stop. However, the claimant failed to produce any substantive proof with regard to his actual occupation and earnings by the date of accident. Full stop. Considering the whole body disability as 4%, taking the notional income as rupees 12,000 per month, the tribunal awarded a sum of rupees 86,400 towards loss of future income. Full stop. The tribunal also awarded a sum of rupees 72,000 towards loss of earnings during laid-up period. Full stop. The tribunal also awarded substantial sum under other heads. Full stop. Therefore, this court does not find any grounds to interfere with the amount that is awarded as compensation and to enhance the same as paid for. Full stop. Thus, in the light of the foregoing discussion, with regard to merits of both the appeals, they are disposed of with the following order. Both the appeals, that is MFA so-and-so and MFA so-and-so, are dismissed without cause.
Amount in deposit.
Amount in deposit, if any, be transmitted to the concerned tribunal immediately.
Mobilize first.
Interlocutory applications, if any pending, shall stand closed.
Serial number 32,
I am for the appellant, my lord.
K. Sridhara.
Yes.
In this case, I represent respondent number 1, my lord.
Yes.
Memo has been moved by me requesting this honorable court because the deposit is there. My client want to take the deposit with the kind permission of honorable trial court. LCR.
Records have come. Call for the records from the concerned tribunal. We list on 23rd October.
Much obliged, man.
Obliged, my lord.
Serial number 33,
My lord, I am for the respondent, my lord. I am ready.
ND.
My lord, other side is pending, my lord, held up in quota number 10. Kindly pass over. I am ready, my lord.
Pass over.
Pass over. Serial number 34, Manjunath ND.
Second respondent.
GS Marulaya for respondent.
It's the accident in the year 2007.
No representation on appellant side, Mr. Counsel. No representation on appellant side on call. To give fair opportunity, list on 29/10.
Serial number 35, Krishna Kishore.
Respondent.
V. Srinivas for respondent.
But even I have also filed one cross objection. MFA Crab 5 of 2024. It may
Counsel,
be.
you have not filed acknowledgement having deposited.
I have received it today, my lord. I will file it today. My lord, it was
Deposited,
it
huh?
was deposited on 30th of September 2021 itself, my lord, before tribunal, my lord. 5,75,114.
Sri Krishna Kishore, yes. For appellant submits that the amount as ordered was deposited.
Before the tribunal.
Deposited, full stop. Land counsel states that he would file the acknowledgement forthwith. Full stop.
Lord, kindly.
My lord, I have filed cross objection, my lord. Cross objection number 5 of 2024. This may be called a land.
Counsel, you are Mr. Srinivas V.
Yes, madam.
Land counsel Sri Srinivas V for respondent number 1 submits that respondent number 1 filed a cross appeal wide MFA crop
5 of 2024.
5 of 2024. Full stop. Seeks to list both the matters on the same day. Full stop. Registry to verify and to release the present appeal along with MFA crop so and so on 23rd September.
In the meantime, LCR may kindly.
LCR necessary. Then we'll admit.
Like LCR, my lord, the only short point what my learned friend has raised is DL irlilla avrige offending vehicle driver ge DL irlilla anta heli. Well, I'm sorry, my lord.
Call
I'm
for
sorry.
the record
Leader,
from the
Lord.
consent tribunal in the meantime.
Okay.
Serial number 36, Srinivasan MY. B. Pradeep.
And for respondent, my lord. There's 2 days time, my lord. File wakalat, my lord. Intimated to company has been couried today, my lord.
You were directed to take notice in the month of November 2023.
Please, my lord. Plus 2 days time, my lord. I will file wakalat, my lord.
We'll change the council if you have so much of work. Why should we entrust to you?
No, courier has been made, my lord, insurance company. Courier has not received that problem. Yesterday I have informed to company, my lord. Yeah, today has been couriered.
Sri Mallikarjun Reddy representing Sri P. Pradeep seeks time to file wakalat for respondent number 2. Full stop. Sri B. Pradeep was directed to take notice for respondent number 2 in the month of November 2023. Full stop. However, wakalat is not filed till now. Full stop. To give fair opportunity, time for 2 days is granted. Full stop. Released on 13th September.
Please, my lord. Much obliged.
Serial number 37, yes, Nirmala Mahadev Swami for respondent.
And for the appellant, my lord. Lord, this is a case for claiming the damages of the vehicle, my lord.
Have you
Filed by the-
deposited the amount, Amma?
My lord, we have deposited, my lord. We have
You have
deposited.
not filed the acknowledgement.
I'll file it. I'll file it.
Srimati S. Nirmala for appellant submits that amount as ordered was deposited. Full stop. Also states that she would file acknowledgement to that effect. Full stop. No representation on respondent side on call. Full stop. Acknowledgement of having deposited the ordered amount be furnished within 2 days. Full stop.
No, not 2 days, my lord. I have to get it from the division, my lord. So kindly have it a week's time, my lord.
It was ordered in the year 2021, Amma.
We have deposited, but I have not produced, my lord. That's
What did
I
you
have
write?
deposited already. As per the, because stay has been granted, I have deposited, my lord. I'll get the receipt and produce it, my lord.
Within 8th September.
Serial number 38, Manjula Tejasvi.
My lord, kindly call the
Sushmita.
records also.
Happy for respond to this
Call
case,
for
my lord.
records, my lord.
Your lordship.
Yes, case.
Your lordship,
Call for records from the
appearing,
consent tribunal in the meantime. Yes, Amma.
Much obliged.
appearing
Serial number 38.
in serial number 38. My lord, there's a connected matter, my lord. I'm appearing for the appellant, my lordship. The delay of 79 days may kindly be condoned in this case, and there is a connected appeal filed by the insurance company having the number of 2292 of 2021, your lordship. The same may kindly be posted along with this matter.
Srimati Manjula in Tejasvi learned counsel for the appellant who appears online. Also heard Ms. Susmita Chi learned counsel for respondent number 1 who appears physically before this court. IA 1 of 2021 is filed seeking the court to condone the delay of 79 days in filing the appeal. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the grounds urged, command the delay as prayed for is condoned. Next para. Srimati Manjula in Tejasvi submits that MFA
2292 of 21.
Double
2292.
2021 is connected to the present appeal. Seeks to list both the matters on the same day. Full stop. Registered to verify and to list the present appeal along with the MFA so and so on 15th October.
Can it TCR meanwhile, the TCR may kindly
Call for the
be
records from the
conferred.
consent tribunal in the meantime.
Much obliged. Obliged.
Serial number 39, Syed Abdul Sabur, Jwala Kumar for R2.
Appellant in this case, my lord. It is a case of injury, my lord.
Yes, Mr. Counsel.
Yeah, it's a case of injury, my lord. The tribunal has taken 5,000 as income instead of 8,000. And globally, it has been awarded because since he has not produced he has produced a one certificate, but he has not take the evidence of the doctor. Though he has suffered two injury on the both the legs, my lord, as well as wrist. The fracture of medial malleolar left as per Exhibit P5, one certificate. And he has incurred a medical expenses of almost 1,482, my lord. Left arm, left wrist, injuries to both legs.
So 75,000 was awarded as
Global, my lord,
globally.
without considering a disability.
You did not examine any doctor.
That injury is a grievous in nature, my lord, on his both legs.
How can we increase, Mr. Counsel?
He is hospitalized for more than 20 days.
Even if the income is taken as 8,500 per month, the loss of earnings for 2 months comes to rupees 17,000. Pain and suffering 25,000 and other hits. Even then it will not be more than 75,000.
Disability has not been considered.
Huh?
Disability has not been considered.
You have not established.
Yes.
Yes.
My lord, the award is just and reasonable, my lord. There is no medical evidence on record to substantiate the disability.
Yes.
It is a case.
Later period and amenities and other things considered. Pain and suffering.
We will increase by 10,000, Mr. Counsel.
My lord, even pain and suffering and later period 3 months, it will be 24,000 plus 30.
Who has to speak, Mr. Counsel? You have not examined the doctor. Yes, we'll increase by 10,000. Yes.
Yes, ma'am.
Heard. Sri Syed Abdul Sabur.
My lord, I would round it up to 25,000 at least.
Heard, Sri. If there is any like any material, we would be more than happy to increase, but there is no material. Heard, Sri Syed Abdul Sabur, Land Counsel for the appellant, who appears physically before this court. Full stop. Also heard, Sri Jwala Kumar, Land Counsel for second respondent, who appears online. Next. Seeking this court to award the claimed amount as compensation, this appeal is preferred. Full stop. The appellant disputes the findings that are given by the Motor Accidents Claims Tribunal, Mysore, in MVC 850 of 2015, dated 25/1/2021. Full stop. As against the claim for rupees 18,25,000, the tribunal through the impugned order awarded a sum of rupees 75,000 as compensation. Full stop. Next. Arguing the matter, Sri Syed Abdul Sabur contends that the appellant sustained grievous injuries in a road traffic accident and became totally disabled. Full stop. He is unable to attend his normal pursuits. Full stop. Though sufficient evidence was produced to establish the nature of injuries sustained, the hospitalization, the treatment, and the aspect of disability, the tribunal awarded a global sum of rupees 75,000 as compensation, which is unjustifiable. Full stop. Land Council thereby seeks to enhance the amount. Full stop. Next. The submission that is made by Sri Jwala Kumar for respondent number 2, on the other hand, is that the appellant failed to produce any proof to establish the alleged permanent disability. Full stop. Land Council states that except examining himself as PW1, the appellant did not examine any other witnesses. Full stop. Land Council further submits that the amount awarded as compensation under different heads by the tribunal is justifiable, and thus the award needs no interference. Next. A perusal of record reveals you remove it. The tribunal basing on the contents of Exhibit P5 wound certificate coupled with exhibits P7 to P13 came to a conclusion that the appellant is entitled to a sum of rupees 75,000 as compensation. Full stop. As per the contents of Exhibit P5 wound certificate, the appellant sustained fracture of medial malleolar left and 2 other simple injuries. Full stop. However, the appellant did not choose to examine the doctor who treated him or any person who assessed the disability. Full stop. Likewise, the aspects of hospitalization and the medical expenditure were also not established. Full stop. Therefore, the tribunal awarded a global sum of rupees 75,000 as compensation. Full stop. But taking into consideration the fact that the appellant sustained 1 grievous and 2 simple injuries, this court is of the view that the appellant would have certainly took treatment for getting those injuries healed. Full stop. The appellant did not even establish his exact occupation and income by the date of accident. Full stop. Therefore, having regard to the fact that having considered these facts, this court is of the view that globally a sum of rupees 10,000 is liable to be enhanced for making the compensation just and reasonable and proportionate to the injuries sustained. Full stop. Therefore, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Mysore, through orders in MVC 850 of 2015, dated 25/1/2021, is enhanced by rupees 10,000. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire order.
Serial number 40, Prakash MH, SV Hegde Mulkhan for respondent.
My lord, I appear for the respondent, my lord.
For the appellant, Lordship. Lordship, in this case, it's a case of death. There's only enhancement for the income of, which has been taken at the lower side. The accident is the year of 2019. The MSCT is taken 11,000, Your Lordship, instead of 14,000 as per the chart.
Present Balaji.
Yes, Mr. Counsel.
Yes, madam. But the petitioner says that the deceased was a mechanic, but my lord, no credible evidence has been placed on record. So in such circumstances, my lord, the tribunal has generously taken 11,000. Usually your lordship is also taking 10,000 rupees. So 10,000 may be considered and matter can be.
10,000.
Sorry, 11,000 has been taken, and 11,000 seems to be in the fact and circumstances very, very reasonable, because they are not based on any credible evidence regarding this. So that's why, my lord, I will leave it to your lordship, my lord.
Any further submission, Amma?
No, Your Lordship. I admit with the fact that we have not adduced any evidence insofar as of the
1,20,000 towards a loss of filial consortium. How can it be 1,20,000?
Lordship. The dependents are his father and mother.
Hmm.
And he
And
died.
the elder brother.
Elder brother, Your Lordship.
Hmm. Yes.
Your lordship is seeing, my lord, Sriram General Insurance Company case. My lord, 70,000 only they are entitled under that.
Yes. Third, Miss Nitya, who represents Sri Prakash MH, Land Council on record for the appellants. Full stop. Land Council appears physically before this court and argues. Full stop. Also heard Sri S.V. Hegde Milken, Land Council for respondent number 1, who appears online. Who appears through VC. Full stop. Next. The first appellant being the father, the second appellant being the mother, and the third appellant being the elder brother, filed a petition, elder brother of the deceased Imran, here within brackets hereinafter be referred as the deceased for brevity, filed a petition claiming compensation of rupees 25 lakhs in total. Full stop. The Motor Accidents Claims Tribunal, Bangalore, which dealt with the case as MVC 1994 of 2019, passed orders on 29/1/2021, awarding 18 lakhs 13,500 as compensation. Full stop. With a contention that they are entitled to the sum claimed, this appeal is filed. Full stop. Next, Miss Nitya, Land Council for the appellants, contends that the deceased what was his occupation?
He was a mechanic, Your Lordship.
As a mechanic, was earning
15,000 per month.
rupees 15,000 per month by the date of accident. Full stop. But the tribunal took the notional income of the deceased as rupees 11,000 per month and awarded meager sum as compensation under the head loss of dependency. Full stop. Land Council also states that the accident occurred in the year 2019, and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month, and at least the set figure should have been considered by the tribunal. Full stop. Land Council thereby seeks to pass necessary orders. Full stop. Next. Sri S.V. Hegde Milken, on the other hand, contends that the appellants failed to produce any substantive proof with regard to the alleged occupation and earnings of the deceased by the date of accident. Full stop. Land Council contends that in the absence of any proof, the appellants cannot seek the court to consider the occupation and income as projected in their pleadings. Full stop. Next. Admittedly, no proof is produced by the appellants to establish the occupation and income of the deceased by the date of accident. Full stop. It is not in dispute that the appellant died at the age of 20 years. Full stop. This said age is considered to be the right age to start the chosen avocation and earnings. Full stop. Therefore, this court is of the view that the request of the Land Council for the appellants to take the notional income of the appellant of the deceased as rupees 14,000 per month notionally is justifiable. Full stop. Next paragraph. The parameters applied, that is addition of 40% towards future prospects, comma deduction of 50% towards personal and living expenses, and applying the appropriate multiplier 18 needs no full stop. Thus, the loss of dependency on calculation will be as under. Notional monthly income 14,000, annual income 1,68,000, add 40% towards future prospects 2,35,200, deduct 50% towards personal and living expenses 1,17,600, apply appropriate multiplier 18, 21,16,800. Full stop. Thus, the loss of dependency has come to rupees. Thus, the compensation which the appellants are entitled to under the head loss of dependency comes to rupees 21,16,800. Full stop. Together with the said amount, comma, the appellants are entitled to rupees 15,000 towards funeral expenses, rupees 15,000 towards loss of estate, and rupees 15,000 towards loss of estate. Full stop. Appellants 1 and 2, being the parents of the deceased, are entitled to rupees 40,000 towards loss of filial consortium. Full stop. Thus, the compensation which the appellants are entitled to is as under. Loss of dependency 21,16,800, funeral expenses 15,000, loss of estate 15,000, loss of filial consortium 40,000, total 21,86,800. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 18,13,500 as compensation. Full stop. However, the amount which the appellants are entitled to as compensation is rupees 21,86,800. Full stop. Thus, the appeal is disposed of with the following order. Next, the appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal through orders in MVC, Motor Accidents Claims, Principal Motor Accidents Claims Tribunal, Bangalore. And the first also you write. Through orders in MVC 1994 of 2019, dated 29/1/2021, is enhanced from 18,13,500 to 21,86,800. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the second respondent is directed to deposit the enhanced sum.
First respondent, Your Lordship.
Is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. The appellants 1 and 2 are entitled to equal share out of the enhanced amount. Full stop. On deposit, the appellants 1 and 2 are permitted to withdraw their respective shares.
Oblige, Your Lordship.
Serial number 41, adjourn. 42, KL Srinivas, BC Shivannegowda.
Or all to my name. No representation on appellant side on call. Your good name, Mama?
Rashmi MS.
Huh?
Rashmi MS.
Ms. Rashmi, representing Sri BC Shivannegowda for R2 is present before this court physically. Full stop. To give fair opportunity, stand over to 7th November.
Serial number 43, Narendra Gowda, Sharat Kumar HN for respondent.
for respondent number one, my lord, claimant. It's the owner's appeal, my lord.
No representation on appellant side on call.
Last occasion also there. Last occasion also not appeared.
Sri, you are Mr. Sharad Kumar.
Yes, ma'am.
Sri Sharad Kumar HN. For respondent number one, for respondent is present before this court physically. It's to give fair opportunity list on 5/11.
October, my lord, in the month of October.
List on 22nd October.
Please, ma'am.
Serial number 44, Uday Kumar L, BC Shivannegowda.
For all to.
Uday Kumar RL, 44.
No representation on appellant side on call. Miss Rashmi representing Sri VC Shivanagoda and counsel for R2 is present before this court physically. To give fair opportunity, stand over to 24th September.
Number 45, Sanat Kumar KM. Respondent served unrepresented.
May I take notice for respondent, my lord?
Your good name, Mama?
Kalavati.
Huh?
Kalavati.
Miss Kalavati, representing Sri Sanat Kumar KM and counsel for the appellant is present before this court physically. Full stop. Sri Vijay Kumar D waives notice for respondent, seeks time to file wakalat. Full stop. Time for 2 weeks is granted to file wakalat. Full stop. Appellant to serve copies of appeal papers at the chambers of Sri Vijay Kumar D. List on 27th September.
Much obliged.
Serial number 46, Parmesh Shappa, yes, Kumara KG. Serial number 46.
No representation on either side on call. To give fair opportunity, list on 24th September.
Serial number 47, BS Sachin.
Claim petition set off and dismissed, my lordship, on the ground that liability in
D Vijay Kumar for respondent.
Mr. Vijay Kumar, you undertook to file wakalat.
In which matter, my lord? Which serial number, my lord?
47, sir.
My name is not shown, my lord. I'll verify and
1358.
I'll file wakalat, my lord, within a week. My name may be shown.
Your good name
In the
is-
cause list, my name is not shown.
Your good name? Sri Harsha, representing Sri Sachin BS. Land counsel on record for the appellant is present before this court physically. Full stop. Sri D Vijay Kumar seeks time to file wakalat for the respondent.
My lord, direct the appellant to give me the copy, my lord.
Full stop. Appellant is directed to serve copies at the chambers of Sri D Vijay Kumar. Wakalat to be filed within 2 weeks. List on 20th September.
LCR is required.
Serial number 48, Gurudev Prasad KT.
Ma, in the meanwhile, call for records from the consent to.
48, A Ravi Shankar for respondent.
I appear for the appellant. Ignored. Say, ready. It's a case of injuries. Para 11 of the judgment. He suffered a fracture of right femur. Para 11.
He was admitted in the hospital for 7 days. He had surgery and internal fixation to right femur. The doctor PW2 assessed a physical impairment at 54% to the limb and 18% to the whole body. So for pain and suffering, 75,000 is awarded, no grievance. Loss of income during a later period. Learned judge has assessed the monthly income at ₹9,000. The accident is during the 16/3/2000.
What was his occupation?
Agriculturist,
63 years.
63 years. Court has assessed ₹9,000. Accident during the year of 2019.
Yes.
No amount is awarded for loss of future earnings. Loss of amenities 50,000, future medical expenses also, conveyance, nourishment.
Everything is reasonable, Mr. Counsel.
Please,
We cannot interfere.
no, he is an agriculturist, aged about 63 years, 18% to whole body disability he suffers.
He has not issued any disability certificate also,
He,
PW.
PW2 doctor who has treated him has appeared before the court and he has given
How could
evidence.
he say?
He only has to say in the court and he only has to give a disability certificate.
He has
Both-
not issued.
both-
Why did he examine him? How can he remember the percentage of disability?
He has examined after taking X-rays and after going through the X-ray and after examining him physically.
Status improved, fracture united, mobility and stability variations are nominal.
For an agriculturist, naturally it comes in the way of his.
Yes, Mr. Counsel, what do you say?
There is nothing on record to establish because he could
Doctor-
have treated, he could have examined the doctor who treated him. He did not choose to examine.
He-
The doctor.
PW2 is the doctor.
He has
taken X-rays
Sir, one
and present condition he has assessed. And
Hello.
on the basis of X-ray and physical examination, he has given
The doctor is
evidence
examined
before the
only for
court.
this particular
What
case.
else is required?
He did not treat him. He has brought him to the court.
Ah.
Just before that, he has examined and says that he has got 18%. There is no treatment as such. And he does not say that he could not examine the doctor who treated him. Only for this particular limited purpose, he has brought him here.
Or else I will get the disability certificate and produce before this honorable court.
As you wish.
Yes.
Learned Counsel, Sri Gurudev Prasad Keti seeks time to move an application for production of additional evidence. So therefore,
Don't do that.
stand over to 15th October.
15th October.
Serial number 49.
Yes, I.
Respond.
Here also disability
doctor.
certificate has not been produced.
Same
But
doctor.
on the other hand, doctor has been examined. I will produce the.
Same doctor.
Same order.
Serial number 50, K. Vishwanath Pujari, Manoj Kumar MR for R3.
Mistake that two appeals filed by the under same impugnant. I am withdrawing the one appeal. My first appeal I will withdraw. That's file memo for withdraw the serial number 50. 1930.
Learned Counsel Sri Vishwanath Pujari for appellant files a memo seeking permission to withdraw the appeal, that is MFA 1913 of 2015. Which the permission as prayed for is accorded. The appeal in MFA 1913 of 2022 is dismissed as withdrawn.
In second appeal matter may refer to Lok Adalat.
So far as MFA 1801 of 2021 is concerned, at request of Learned Counsel Sri Vishwanath Pujari K for appellant, the matter is referred to Lok Adalat for settlement.
Serial number 51, K. Prasanna Shetty.
My lords, for the appellant, my lords. My lord, as per your order, we have paid the cost and we have submitted the memo, my lord, on 21/8. My lord, the liability is fastened on respondent 2, my lord, so kindly dispense the respondent 1, my lord. Memo, please. Notice has to be served, ma'am.
You are Mr. Prasanna Setti.
No, ma'am. Bharat. Bharat.
Heard Sri B. Bharat, who represents Sri K. Prasanna Setti, Learned Counsel on record for the appellant.
My lord, notice has to be served, my lord.
Memo filed seeking dispensation of notice upon respondent number 1. Full stop. Learned Counsel states that as liability is fastened upon respondent number 2, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Sri Krishna Kishore S is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Instruct appellant to serve copies of appeal papers at the chambers of Sri Krishna Kishore S. Time for 2 weeks is granted to file wakalat. List on 110.
Serial number 52, B.S. Umesh.
My lord, I have appellant. My lord, 163 petition, the question of liability does not arise as far as the insurance company is concerned. Records may be necessary in this matter, my lord.
At request of Sri B.S. Umesh, Learned Counsel for the appellant who appears online, call for the records from the consent tribunal.
Please, ma'am.
List on 28th October.
Serial number 53, G. Lakshmish Rao. R1 served unrepresented. Serial number 53.
No representation on appellant side on call. Full stop. As per the office note, acknowledgement of having deposited 50% of the award amount is not filed yet. Full stop. The order was rendered on 8/4/2022. Full stop. Therefore, this court orders that in case the amount as ordered was not deposited within a period of 4 weeks, commencing from 8/4/2022, the appellant would be at liability to deposit the entire award amount, and such deposit should be within a period of 4 weeks from this day. Full stop. List on 30th September.
Number 54, adjourn. 55, Kumarappa TC. L. Srikant Rao.
All for TCR. Claim petition is dismissed.
Fraud and misrepresentation. Second time it's being, the posture, the appeal they have preferred the second time. First time, the honorable court has decided that the documents produced are not proper and remanded the matter to give an opportunity. Again, the same observation with the said observations, the petition has been dismissed. It has taken 16 years as of now. 8 accident.
Let us see. You are Mr. Shivkumarappa.
Yes.
Heard Sri Shivkumarappa TC, Land Counsel for the appellant, as well as Sri L. Srikanta Rao, Land Counsel for respondent number 2. Admit, call for the records from the consent tribunal. List on 29th October.
Please.
Much.
Serial number 56, Viresha K. Yes. SV Hegde Mulkan. Serial number 56, Viresha K. SV Hegde Mulkan for respondent.
No representation on either side on call.
My lord, I appear for the respondent.
No representation on appellant side on call. You have not filed wakalat, Mr. Counsel?
My lord, it seems, my lord, in the call list, my lord, Srikant Rao's name is shown, my lord. You lot may. Sorry.
56, Nimde ide, sir.
Sorry, my lord, sorry.
You have not filed wakalat, Mr. Counsel.
My lord, I looked into the this my lord trial court judgment, but my lord, the only in respect of income it is to be deferred.
You
I
have
think
not filed wakalat, Mr. Counsel.
2 weeks time may kindly be granted so that I can.
Sri SV Hegde, no representation on appellant side on call. Sri SV Hegde.
It seems, my lord, the copies are not given. It seems, my lord.
File
I just
Full stop. Time as set for is granted, as sought for is granted. No further time will be granted. List
may
on-
request, my lord, only question of quantum Lok Adalat it may be referred.
There is no representation for the other side, Mr. Counsel. List on 23rd September.
Serial number
My lord, when it
57,
is posted, my lord?
sir, 23-9.
Obliged.
Serial number 57, Vijay Kumar T.
Okay, for the appellant.
My lord, I am for the respondent, my lord.
It may be
Matter may be referred to Lok Adalat.
At request of both the Land Counsel, that is Sri Vijay Kumar T and Sri D Vijay Kumar, the matter is referred to Lok Adalat for settlement.
Much obliged.
Serial number,
In the forthcoming Lok Adalat.
sir, ಬರುತ್ತೆ ಅದು ಆ ಟೈಮಲ್ಲಿ ಹಾಕ್ತಾರೆ sir.
Okay, much obliged.
58 adjourn, 59 adjourn, 60 Sushmita ji. SV Hegde Mulkan for respondent, serial number 60.
For the respondent, my lord.
No representation on appellant side on call. Sri SV Mulkan for respondent number 2 appears online. To give fair opportunity, list on 24th September.
Serial number 61 adjourn, 62 AS Girish,
I represent the appellant in.
PV Raju for R2.
It's a claimant's appeal for the enhancement of compensation. Your Lordship.
There is no representation for the other side.
PV Raju.
We'll have it on Monday.
Yes, Monday.
Sri S. Girish for appellant is present before the court physically.
Sorry, I represent A.S. Raghavendra. My name is.
Sri Raghavendra representing Sri A. S. Girish for appellant is present before this court physically. Full stop. However, there is no representation on respondent side. Full stop. As Sri P.B. Raju is on record for respondent number 2, comma, office is directed not to show the name of Sri Ravish Binni. Full stop. List on 2nd September.
Second, serial number 63, Sharda N.
Claim petition has been dismissed. On the basis that the claim petition has been filed with a delay, my lord.
Third, Srimati Sharda N, Land Counsel for the appellant. Huh?
PV Kalpana for
Third,
Sharda, my lord.
Srimati P.V. Kalpana, Land Counsel who represents Srimati Sharda N for appellant.
My lord, New India Assurance Company, I
Yes.
may be permitted to serve on a council. Others, for others, I'll take notice, my lord.
Sri C.R. Ravishankar is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri C.S. Ravishankar. Full stop. Issue notice to respondents 1 and 3 on furnishing the requisites. List on 23rd October.
Much obliged.
Serial number 64, Shankar Prasad. MB, BR Venkatesh. Serial number 64, Shankar Prasad MB.
No representation on either side on call. Full stop. There was no representation on appellant side even on 10/6/2024. Full stop. To give fair opportunity, list on 17/9/2024.
Serial number 65, MV Maheshwarappa.
In this case,
AN Krishnaswamy.
case of injuries, I filed an application for additional evidence. Advocate for R3.
Yes. You have not filed wakalat N. Krishnaswamy.
I am representing.
Wakalat not filed.
Not filed. Okay, inform madam. Inform.
Sri N. Krishnaswamy has not filed wakalat for R3. Full stop. To give fair opportunity, time for a week is granted. No further time will be granted. Relist on 1st October.
Good.
Serial number 66, adjourn. 67, Sridhara DS. A Ravishankar for R2.
For respondent. I pay for respondent.
No representation on appellant side on call. Your good name, Mama?
Lokesh, see Lokesh.
I'm also there, my colleague.
Yes. No representation on appellant side on call. The appeal is of the year 2021. Full stop. However, to give fair opportunity, stand over to 12/9/2024.
Sixty-eight, adjourn. 69, Syed Abdul Sabur. Krishna Kishore for R2.
Respondent.
No representation on appellant side on call. To give fair opportunity, list on 25th September.
Good.
Serial number 70, T. Vijay Kumar, Sohani Holla.
Ready, my lordship.
Why two appeals?
Two appeal filed by the claimants, my lordship, for enhancement. Case of injury, lordship. The accident occurred on 6/8/2017, lordship. In MVC number 2959 of 2019, my lordship. In this case, my lordship,
Where is the other record? Court officer. So on quantum,
on quantum. The injury sustained, lordship, compound comminuted fracture of the lateral 1/3 right tibia with ankle dislocation. Deglowing injury of the right ankle, displaced fracture of the
oh, in which matter you are arguing?
lordship, the tribunal has not
In which
consider
matter
and
you are
award.
submitting, Mr. Counsel? Now in which matter you are submitting?
My lordship, in
It is in 2959 or 2960?
2959.
2959.
59. Inpatient for a period of 5 days. The injury mentioned in the judgment, page number 12, my lordship. In page 12. TWF4 deposed that he has sustained compound comminuted fracture of the lateral 1/3 right fibula with
What the nature of injury sustained?
my lordship, compound comminuted fracture of the lateral 1/3 right fibula with ankle dislocation.
This is wound certificate, exhibit P5.
In judgment, page number 12.
Yes. So he sustained 4 grievous injuries.
Please, my lordship. And the doctor assessed disability towards physical disability of right lower limb at 37% and to the whole body at 12%. The occupation of the claimant, my lordship, interior designing and earning of rupees 5,000 per day, my lordship.
Where is it found?
Next, in next paragraph. 5,000 per day interior designing, but the tribunal has not considered the same, my lordship. Reasoning that, my lordship, I have not to produce it in a iota of documents. The And other rates, my lordship, for food and extra nourishment and medical attendant, only 2,000 was awarded. The inpatient for a period of 5 days, my lordship. And amenities and laid up period also on lower side, my lordship. Kindly put. The disability at 37%, my lordship. Future prospects can be awarded.
There's no documents which they have produced to prove the income, your lordship. Absolutely no documents. They are saying that he's earning 5,000. They have not produced any documents. The doctor who has treated is not the doctor who has deposed. The deposed doctor is not the same who has treated, your lordship. And then there's no disability certificate produced by the doctor also. Page 9 and 13 of the judgment may kindly be seen. They have already claimed medical bills are not produced because they have already claimed the medical bills under the insurance, your lordship. And he states in his cross-examination that he has received 4 to 5 lakhs of rupees. Medical bills have been submitted to the insurance company and he has already received. So that is the reason why medical bills were not produced, your lordship. And then that is come in page 9 of the judgment, para 10.2. And page 13, page 12 of the tribunal judgment, your lordship. The petitioner has contended that he was doing self-employment in interior designing and earning a sum of rupees 5,000 per day. In order to prove his income, the petitioner has not produced iota of documents before the tribunal. On perusal of cross-examination, he has deposed that he is paying income tax till today, and he has no problem to produce the documents. Further, he has deposed that he is possessing the documents to show that he was earning rupees 5,000 per day. On meticulous perusal of cross-examination of PW1, it shows that he is paying income tax, but he has not produced any documents to show that what was his income prior to the accident and what his income after the accident. So there is no evidence before the tribunal to show that there was loss of income due to accidental injuries. So first thing is profession itself is not proved, your lordship. Income is not proved. And loss of income after the accident also has not been proved, your lordship. Nothing on record.
My lordship, in the absence of documents, my lordship, notional income kindly be taken, my lordship.
The doctor says that he has not assessed the functional disability also in his cross-examination in Kannada, your lordship. And all the fractures have been healed is what he says. ಎರಡು ಮೂಳೆ ಮುರಿತಗಳು ಕೂಡಿಕೊಂಡಿರುತ್ತವೆ ಎಂದರೆ ಸರಿ. All has been joined.
But he deposed that the disability is there, Amma.
Yes, your lordship. But he has not spoken about functional disability as such. The doctor.
12% to the whole body.
Yes.
Yes, your lordship.
What about the other case?
In other case, my lordship, the
2961.
injury sustained, lordship, para number 13 in page number 14 of the judgment. In this case, my lordship, notional income 40,000 only awarded, my lordship. There are 2 fractures and other simple injuries. Okay. Para 13. Blunt injury to chest with multiple rib fractures with lung contusions and first and second, fourth and seventh rib fracture is caused to the appellant, my lordship. On the 40,000 on lower side.
In this case, your lordship, no disability certificate is
Exhibit
produced.
P10.
Doctor not examined.
Doctor has not been examined, your lordship, and no medical bills have been produced in this case. Doctor is not examined, medical bills are not, absolutely no evidence, your lordship. And discharge summary also doesn't state anything about fracture, your lordship. If your lordship goes through exhibit P11, the discharge summary. Just for a day, she was admitted on 28th and got discharged on 28th itself. After many days of the accident, your lordship. The accident occurred on the day 6/8/2017. And they've produced a document on where she's been admitted on 28/8. After 22 days, she gets hospitalized. There's no fracture, nothing. It just says the admission diagnosis left sectory otitis media, something to do with the mixed hearing loss. Deviated nasal septum, other allergic rhinitis.
There were multiple rib fractures, Amma.
Nothing, she's not got treatment for that, your lordship. There's no medical evidence at all.
6/8, she got admitted and discharged on 9/8. 3 days she was there as inpatient.
Discharge summary of Columbia Asia, it is on 28th she gets admitted, 28th itself she gets discharged, your lordship.
What about exhibit P10?
There's no discharge summary. That's a wound certificate. There's no discharge summary for those dates, your lordship.
28/8.
Absolutely no record to show that any surgery was performed on her.
What is the date of accident?
6/8/2000.
So she was there till 9/8. Thereafter, she took treatment on the same day. Patient was discharged on 9/8.
No discharge summary has been produced for that particular period.
Mr. Counsel, what do you say?
Sir, my lordship, the injuries are grievous in nature, my lordship.
2 simple and 1 grievous.
One grievous, my lordship. Only 40,000 has ordered. That is the only grounds, my lordship.
We cannot enhance in this. Yes. So far as the first matter is concerned, MFA 6480 of 2022. So The tribunal awarded 1,02,000 as compensation. Totally.
Yes.
It is enhanced to 4,61,200. Yes. We'll dictate after lunch. Okay.
I have a matter in the afternoon session if I'm.
Yes, no. So we'll dictate these two matters for dictation and pay. Those two matters, one Passover. Passover matter will adjourn.
Income ಹಿಡ್ದಿಲ್ಲ.
ಪಾಸ್ವರ್ಡ್ ಮೂರಿದಾವೆ. ಪಾಸ್ವರ್ಡ್ ಡಿಕ್ಟೇಟಿಂಗ್ ಎರಡಿದಾವೆ ಪಾಸ್ವರ್ಡ್ 33 33 33 ಆಮೇಲೆ ಇನ್ನೊಂದು 70. ಇಲ್ಲ ರಾಹುಲ್. ಸೆಟ್ ಆಗಲ್ಲ, ಮಿಸ್ಟೇಕ್ಸ್ ತುಂಬಾ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲಿದ್ರು
Yes. ಏನಿದ್ರು ಅಡ್ಮಿಷನ್ ಫೈನಲ್ ಇಯರಿಂಗು ಡಿಕ್ಟೇಟ್. ಇಲ್ಲ ಹಿಯರಿಂಗ್ ನೀಟಾಗಿ ಎಕ್ಸೆಪ್ಷನ್ ಡಿಜೆ ಕೆಡ್ರನ್ನವ್ರಿಗೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇರಬಾರ್ದು.
My lord, the court is not audible, my lord.
I'll wait
Ah,
for him. He's
Now
here
I
only.
can hear. Madam.
He's here only.
We'll have it day after tomorrow, on Saturday. No representation on appellant side on call. Sri D. Vijay Kumar for respondent number 3 reports ready. However, to give fair opportunity, stand over to 31st August.
31st.
Yes. Next. Hmm? वो order dictate करने का. हाँ. Date. Hmm?
130 was JP. Last 130.
हाँ, वही तो.
Serial number 70, T. Vijay Kumar, Sohani Walla, for respondent.
It was argued by
Sohani.
Sohani. Morning, who came for dictation? Yes. From chamber. Another? Why again from typing pool? What happened to our person secretaries, both of them? Hmm. Why? Huh? Okay.
Serial number 70.
Appellant, my lord.
Third, Sri Vijay Kumar T, Land Counsel for the appellants in both the appeals, and Srimati Sohani A. Holla, Land Counsel for the respondent in both the appeals. Full stop. While MFA 6480 of 2022 is filed by the claimant in MVC 2959 of 2019, comma, MFA 3533 of 2022 is filed by the claimant in the MVC 296161 of 2019. Full stop. Both the said motor vehicle cases were pending before the Motor Accidents Claims Tribunal, Bangalore. Full stop. Both the cases were disposed of through a common order dated 5/3/2022. Full stop. The claimant in MVC 2959 of 2019 was granted compensation of rupees while the claimant in MVC 2959 of 2019 was granted compensation of rupees 1,02,000, the claimant in MVC 2961 of 2019 was granted compensation of rupees 40,000 in total. Full stop. Both the claimants, aggrieved by the sum awarded, seeking enhancement of compensation are before this court through these appeals. Full stop. Next, heading entitlement of compensation in respect of claimant in MVC 2959 of 2019, who is the appellant in MFA 6480 of 2022. That is heading with bold letters, you write and underline. Full stop. For trial court records. Yes. It is not in dispute that the claimant Sanjeev
Name Sanjeeva, Sajeeva, sir.
Sajeev.
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 Saj,
Sajeev.
Sanjeev or Sajeev?
Sajeev. Ma'am.
The claimant Sajeev sustained lacerated wound, a lacerated wound over medial aspect of left ankle, comma, compound comminuted fracture of right fibula, comma, displaced fracture of left forearm, and joint dislocation of right ankle, which are grievous in nature. Exhibit P5 contains reveals that those injuries are grievous in nature. Full stop. Next page. Arguing the matter, Learned Counsel Sri T. Vijay Kumar submits that PW4 examined the appellant and assessed the disability in respect of right lower limb as 37% and in respect of whole body as 12%. Full stop. However, for the reasons best known, the tribunal did not award any compensation under the compensation for loss of future earnings due to permanent physical disability. Full stop. Learned Counsel also states that the appellant Sajeev as an interior designer was earning rupees 5,000 per day. Full stop. However, the tribunal awarded a meager sum of rupees 20,000 towards loss of earnings during treatment period, which is unjustifiable. Full stop. Learned Counsel also contends that the amount of compensation awarded under all other heads is also too meager. Full stop. Learned Counsel thereby seeks the court to enhance the amount. Full stop. Next, Srimati Sohani A. Holla, though contends that the appellant has not furnished concrete evidence with regard to his occupation and earnings, did not deny the fact that the compensation awarded does not match the nature of match the loss sustained by the appellant. Full stop. Next one. The tribunal, through the impugned order, awarded a sum of rupees 1,02,000 as compensation divided under following heads, A to A. Full stop. Admittedly, the appellant sustained 4 grievous injuries. Full stop. The evidence of PW4 is that the disability in respect of whole body is 12%. full stop. However, as his evidence is that in respect of right lower limb, it is 37%, comma, this court considers to take the disability in respect of whole body as 10%. Full stop. Next para. Admittedly, the appellant has not produced any evidence with regard to his occupation and earnings by the date of accident. Full stop. The accident occurred in the year 2017. Full stop. The submission that is made by Sri Vijay Kumar T. Learned Counsel for the appellant in this regard is that the Karnataka State Legal Services Authority is taking the notional income as rupees 11,000 per month for the relevant period, and at least the set figure should be considered. Full stop. Learned Counsel for the respondent did not deny for applying the set figure for assessment of compensation. Full stop. Also, the request made is justifiable. Full stop. Therefore, the notional income of the appellant is taken as rupees 11,000 per month. Full stop. As per the contents of Exhibit P5 and other relevant medical record, comma, the appellant was aged about 36 years by the date of accident. Full stop. Therefore, the appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case, full decision, is 15. Full stop. Also, as per the decision of the Honorable Supreme Court of India in Pranay Sethi's case, comma, 40% of the actual earnings are required to be added towards future prospects. Full stop. Thus, by applying these parameters, comma, the loss of earnings due to permanent physical disability is calculated as under tabular form. Notional monthly income 11,000, annual income 1,32,000, add 40% towards future prospects 1,84,800, apply appropriate multiplier 15, 27,72,000, 10% being permanent physical disability, 2,77,200. Full stop. Next. Having considered the nature of injuries sustained, comma, this court is of the view that the appellant could not have attended his normal pursuits at least for a period of 4 months. Full stop. Thus, the loss of earnings during later period comes to rupees 44,000. Full stop. Also, considering the nature of injuries sustained, comma, this court is of the view that the compensation which the appellant is entitled to under different heads is as under. Full stop. Tabular form. Compensation for pain and suffering for the 4 grievous injuries, 80,000. Towards food, extra nourishment, diet and towards food, extra nourishment, diet and attendant charges, 20,000. Towards conveyance charges, 10,000. Loss of earnings during later period, 44,000. Loss of amenities in life, 30,000. Loss of future earnings due to permanent physical disability, 2,77,200. Total 4,61,200. Thus, the amount that is awarded as compensation is enhanced from 1,02,000 to 4,61,200. Next, next heading. Entitlement of the claimant in MVC 2961 of 2019, who is the appellant in MFA 6533 of 2022. As per the contents of Exhibit P10, wound certificate, comma, the appellant sustained 2 simple injuries, one grievous injury. Full stop. Except examining herself as PW2, comma, the appellant did not produce any evidence in proof of the hospitalization, comma, the medical expenditure, if any incurred, and the allied aspects. Full stop. Having considered the same, comma, the tribunal awarded global compensation of rupees 40,000. Full stop. This court does not find any grounds to interfere with the compensation awarded. Full stop. Next, Virama. Thus, both the appeals are disposed of with the following order. MFA 6480 of 2022 is allowed in part. The compensation that is granted by the Motor Accidents Claims Tribunal Bangalore through orders in MVC 2959 of 2019 is enhanced from 1,02,000 to 4,61,200. Next, the enhanced sum carries interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the claimant is permitted to withdraw the entire amount. Next, the appeal in MFA 6533 of 2022 stands dismissed.
Yes. Obliged.
Please.
Passover matter, serial number 30, for dictating judgment, Srinivasan MY.
Yes.
And for the appellant, my lord.
Yes.
1726.
613.
Where is the sheet? Proceeding. Delay was not condemned, no? Second. Ma, first write the proceeding sheet. IA 1 of 2021 in MFA 1726 of 2021 is filed, seeking the court to condone the delay of 99 days in preferring the appeal. Instead of heard, Srimati S. Nirmala, Land Counsel for the petitioner, as well as Sri Srinivasan M.Y., Land Counsel for the respondent. Land Counsel for the respondent did not raise any objection to condone the delay as prayed for. Full stop. Hence, the delay is condoned. No, you may not finally. Both the appeals arise out of the judgment, out of the order that is rendered by the Motor Accidents Claims Tribunal Srirangapatna in MVC 837 of 2017, dated 3/8/2020. While the claimant filed MFA 613 of 2022 seeking enhancement of compensation, comma, Karnataka State Road Transport Corporation within brackets hereinafter be referred to as the corporation for brevity, brackets close, filed MFA 1726 of 2021, disputing its liability to pay compensation. Next paragraph. Third, Sri Srinivasan M.Y. Land Counsel for the claimant as well as Srimati S. Nirmala, Land Counsel who represents the corporation. Next. The matrix of the case as projected by the claimant is that on 7/6/2009 at about 1:40 p.m. while he was proceeding near Somara Sanekarekar, Chamraj Nagara, as pillion rider on motorbike bearing registration number KA09E 1864, the driver of the KSRTC bus bearing registration number KA01F 7256 drove the said vehicle in a rash and negligent manner and dashed against their bike, due to which he fell down and sustained multiple injuries. Full stop. Next. The tribunal fastening liability upon the corporation directed it to pay a sum of rupees 3,81,925 as compensation. Full stop. Next. Arguing the matter, Land Counsel Srimati S. Nirmala submits that triple riding resulted in the accident to occur. Full stop. The rider of the motorcycle was carrying 2 pillion and thereby he could not control the bike and thus he hit the bus. Full stop. The accident thus occurred and there was no negligence whatsoever on part of the driver of the bus. Full stop. However, basing on a false complaint, a case was registered against the driver of the bus. Full stop. Land Counsel submits that two pillion are not allowed to travel over bike, and the same is in clear violation of the provisions of Motor Vehicles Act. Full stop. Though that plea was taken and established before the tribunal, the tribunal fastened liability against the corporation. Full stop. Land Counsel states that as the rider of the motorbike was at fault, hence the corporation is not liable to pay any compensation. Full stop. Land Counsel thereby seeks to allow the appeal filed by the corporation and thereby dismiss the
ground of appeal, 8 years delay. I have taken that also ground.
Full stop. Learn next. Learn Counsel Srimati Nirmala also contends that the accident occurred in the year 2009. Full stop. However, the claim petition was filed in the year 2019, and thus there is inordinate delay in filing the claim petition, but the said fact was not considered by the tribunal. Full stop. Learn Counsel further submits that the amount of compensation granted under all heads is exorbitant. Full stop. Next paragraph. Contradicting the submission thus made, Sri Srinivas M.I. contends that as on the date of filing of claim petition, there was no limitation for making claims. Full stop. Therefore, the corporation cannot raise the ground of filing the claim petition with delay. Full stop. Learned Counsel also states that on the date of the accident itself, complaint was given to police and the same is gone by record. Full stop. Learned Counsel further contends that the claimant sustained multiple fractures due to the accident and the same was established before the tribunal through cogent and convincing evidence. Full stop. However, the tribunal awarded meager sum as compensation and therefore the claimant filed an appeal seeking enhancement.
Regarding the three persons, Malad,
Huh?
regarding 3 persons, my argument, Malad, para 18, I was, Malad, pillion rider on that day, Malad. Para 18, Malad, I
Learned
have.
Counsel further contends, yes, Learned Counsel further contends that the claimant being a pillion rider, is
Section
being
128
a pillion rider should not be denied compensation.
and Section 128 of Motor Vehicle Act, only penal, only.
Cannot be denied compensation by urging an irrelevant ground that the rider of the motorcycle was at fault. And that
No evidence to show that he was not the rider.
was
Right.
not allowed.
Para 18.
There is no evidence whether who was riding the vehicle.
Yes.
Para 18, apex court judgment also quoted.
Next, a perusal of the impugned order reveals clear and convincing discussion on each and every aspect of the case, more particularly in respect of the pleas taken by rival parties. Full stop. There is no denial of the fact that a complaint was given against the driver of the bus and a case was registered basing on the said complaint. Full stop. Also, there is no denial of the fact that the police, after investigation, filed charge sheet against the driver of the bus. Full stop. The corporation, though, took a plea that there was triple riding and that rider of the motorbike which is involved in the accident was at fault, failed to produce any cogent and convincing evidence to establish that the triple riding, the alleged triple riding, that the triple riding has contributed for the accident to occur. No cogent and convincing evidence is produced to establish that the triple riding contributed for the accident to occur or that the rider of the motorbike was at fault. Full stop. Without there being any evidence in that aspect, the tribunal cannot exonerate the corporation from the liability to pay compensation. Full stop. Next paragraph. Coming to the aspect of quantum, comma, the tribunal awarded a sum of rupees 30,000 under the head pain, shock and agony, comma, rupees 16,205 towards medical expenses, comma, rupees 45,000 towards food, diet, nourishment, conveyance and other incidental expenses, comma, rupees 13,000 towards loss of income during treatment period, comma, 2,52,720 towards loss of income due to permanent disability, comma, rupees 10,000 towards future medical expenses, and rupees 15,000 towards disappointment and discomfort and loss of amenities. Full stop. The compensation thus awarded is highly justifiable. Full stop. This court does not find any grounds.
My lord, the income has to be revised, my lord. The tribunal has taken 6,500. The accident is 2009, my lord. The income has to be taken 4,500. Hence, that has to be revised, my lord. That has to be revised. The
Even
loss of
then-
income towards permanent, because it's my appeal. Disability has to be revised, my lord. Taking the income as per the Adalat is 4,500, my lord. Hence, the whole, it has to be modified, my lord. Because as per Adalat, my lord, it is 4,500. And without there being any document, the tribunal has taken 6,500. That has to be reversed. It is my appeal, my lord.
The tribunal,
Mason.
next pair. The version of the claimant is,
Para 36 of the judgment, my lord.
yes,
Notional income 6,500 per month has been taken.
the appellant, the claimant sustained fracture of medial condyle of right femur,
There was a shortening from 7 centimeter, right leg to the. Para 31 already, para 31. Doctor state that decreasing muscle
Disability has
strength.
taken 18%, my lord.
one minute.
Para 31. madam. The doctor evidence starts from 28.
Fracture of medial condyle of the right femur, comma, fracture of distal part of femur, comma, an injury, fracture of lower end of tibia and fibula, right, comma, lacerated wound on right distal part of left foot, and abrasion on the middle of the chin. Full stop. The contention of the appellant, the contention of the claimant,
31. madam.
is that
Doctor said that decreasing muscle strength up to.
yes, Mr. Counsel, I have gone through the record.
Please.
The contention of the appellant is that as Mason, he was earning rupees 25,000 to 30,000 per month. Full stop. However, the tribunal took the notional income of the appellant
Para 36, my lord.
6,500.
as rupees 6,500 per month to determine loss of earnings. Loss of earnings. Full stop. Though Land Counsel for the Corporation Srimati Nirmala contended that the notional income taken is on higher side, comma, the compensation awarded towards loss of income towards permanent disability that is 2,52,720, and the loss of income during treatment period, that is rupees 13,000, is highly justifiable. Full stop. This court does not find any grounds either to reduce the compensation awarded as pleaded by the corporation or to increase the same as contended by the claimant.
My lord, the Adalat charity is 4,500, my lord.
Ultimate conclusion of this court is
It may
that
kindly be
both the
stated.
appeals lacks merits. Full stop. Resultantly, the following order. Both the appeals stands dismissed without cause.
Amount in deposit transfer.
The amount, if any, in deposit be transmitted to the concerned tribunal immediately. What is the TT, sir? Pending interlocutory applications, if any, stands.
My lord, about the delay, it has to be.
A week time is granted to Srimati S. Nirmala to file wakalat in MFA 613 of 2022. Amma, file the wakalat, amma.
Yes, my lord.